Good morning, this is your Kelso Report for Monday, April 30th, and I'm your host, Clark Kelso. Well, from last week, we have cases dealing with criminal sentencing, the Government Tort Claims Act, product liability, and CEQA to review, all of them state court cases. Let's begin with criminal sentencing. The 4th District in People v. Lee affirmed the trial court's sentencing determination that it could not impose both a personal gun use enhancement under Penal Code Section 12022.5 and a gang enhancement under Section 186.22 because on the facts of the case, the gang enhancement necessarily involved the defendant's use of a firearm. And under the California Supreme Court's decision in People v. Rodriguez from 2009, it is impermissible to impose both a use enhancement and a gang enhancement when the gang enhancement arises out of the use of the gun. That amounts essentially to double punishment. As a result, the defendant in People v. Lee was sentenced to 19 years instead of 24 years for his conviction of assault with a semi-automatic firearm. Well, when the sentence for that count was added to the convictions in other counts, including murder, the defendant actually was sentenced to 96 years to life. Next, a case arising under the Tort Claims Act. After attending a baseball game at Blossom Hill Park in Los Gatos, the plaintiff in Cole v. Town of Los Gatos returned to her vehicle, which she had parked between the north edge of the park and a Blossom Hill Road. While standing near the back of her vehicle, she was hit by a car driven by defendant Rodriguez, who would eventually plead guilty to driving while intoxicated. Plaintiff also brought suit against the town of Los Gatos, alleging as to the town that the road and the area where she had parked, both of which were town property, were in a dangerous condition because their configurations, coupled with their relative locations, induced park visitors to park where she had parked, while inducing eastbound drivers on Blossom Hill Road to drive through that area in order to bypass stalled traffic on the road. The trial court granted the town's motion for summary judgment, finding no evidence that any dangerous condition of the town's property was a proximate cause of plaintiff's injuries, relying mostly upon the fact that the driver of the car was drunk. The 6th District reversed, holding that it remained a fact question whether the configuration of the road and the parking area was such as to create a dangerous condition, whether or not the driver of the car was drunk. In reaching this holding, the 6th District emphasized that there can be multiple causes of a single injury, so that identifying the driver's intoxication as a cause does not, as a matter of law, prevent the town from also being a contributing cause of the plaintiff's injury. The appellate court remanded for further proceedings. Next, a product liability case. A manufacturer of steam generating equipment, steam boilers, that were used at the plaintiff's workplace was one of many defendants in plaintiff's suit for damages arising out of exposure to asbestos. The boilers manufactured by the defendant did not contain any asbestos, so the manufacturer moved for summary judgment on the ground that it did not manufacture, sell, or distribute any asbestos-containing product, that the plaintiff was not exposed to asbestos dust emanating from any of the defendant's products, and raising other defenses. Applying the California Supreme Court's recent decision in O'Neill v. Crane earlier this year, the 2nd District held that summary judgment in favor of the boiler manufacturer should have been granted because, as the court held in O'Neill, quote, a product manufacturer generally may not be held strictly liable for harm caused by another manufacturer's product, close quote, even a product that might foreseeably be used in conjunction with the defendant's product. And finally, we have an interesting CEQA case. In order to give some measure of finality to the preparation of environmental review documents, Section 21166 of the Public Resources Code provides that Once an agency prepares an environmental impact report, or EIR, no subsequent EIR shall thereafter be required for the project, unless certain statutorily prescribed circumstances occur, such as substantial changes to the product or to the circumstances under which the project is being undertaken. Well, Section 15162 of the CEQA Guidelines, the regulations, provides a similar limitation on subsequent environmental review following an agency's adoption of a negative declaration. The Imperial Irrigation District took advantage of Section 15162 in adopting in 2008 certain minor modifications to its previously adopted Equitable Distribution Plan for water in the event of a water shortage. That earlier plan had been approved subject to a negative declaration. The plaintiffs in Abadi v. Imperial Irrigation District challenged the 2008 modifications, arguing that the district should have been required to conduct a full-blown EIR for the modifications. When the district pointed to its earlier negative declaration in Section 15162 of the Guidelines, the plaintiff argued that 15162 unlawfully extended the statutory reach of Section 21166, noting that 21166 refers only to EIRs and does not mention negative declarations at all. Well, in Abadi, the 4th District rejected the plaintiff's argument, adopting the holding in Benton v. Board of Supervisors from 1991 that Guideline Section 15162 is a valid regulation that implements and furthers the purposes of Section 21166 of the Public Resources Code. Accordingly, the court rejected the plaintiff's CEQA challenge to the district's 2008 modifications to its Equitable Distribution Plan. And that's it for today's Kelso Report. Have a great day in the law.